Our next guest, well-known lawyer, he's an author, was the lead counsel on the Allard case, which of course led to the constitutional challenge of marijuana for medical purposes. Regulations allowed someone to grow for themselves or have a caregiver do it for them. Joining us in studio, John Conroy. John, thanks so much for doing this. We appreciate it.
Nice to meet you.
Before we get to what's going on now, we had him turning on weeks and weeks ago, and I'm always fascinated. He was from the south of the border, and we wondered how you got involved in the first place. And I imagine a case comes across your desk at some point, and the rest kind of just follow suit. What was it for you?
Well, I was aware of cannabis to some extent before I started practicing law, but not to a great extent. And it was once I started practicing criminal law and defending people that I was politicized by what judges were doing in terms of sending people to jail in those days for simple possession and things like that. And, you know, these were people who drank alcohol and smoked cigarettes and popped Valiums and things like that. And so the hypocrisy was a bit much. And of course, when you're practicing criminal law, you're dealing not only with whether the person has done it or not, but the penalties. And so doing that to somebody for something that I knew from my history growing up. My father was a consultant on the growing of tobacco in Africa. I knew Africans who smoked dacha, they called it,
right.
Cannabis. And if he saw a marijuana plant amongst the tobacco plants, he'd pull it up and throw it on the ground, and the sky didn't fall in. And so, you know, I had come into a situation where even alcohol wasn't as controlled in Africa as it was when I came here. I was surprised that young people couldn't go into a bar, say, with the parent. Not
right.
that they could drink, but at least be with the parent, things like that. So it was an eye-opener to me. But then things changed over the whole period of time that I've been practicing. And so we're in I didn't know anything about the medical and that sort of thing in those early days. It was all criminal law and punishment and trying to prevent that from happening.
And I would think that once you took one case and showed an interest in it, like in the sense of, yeah, there is a hypocrisy to this. It wasn't just that you took the case and moved on to your next case, that other people that would find themselves in that legal, you'd become the guy to go to.
Well, that really started once in about, I guess it would be mid to late 70s when I took on the role as the lawyer for the Abbotsford Community Law Office, which was a new concept in terms of delivering legal services with trying to focus on the issues that were important in the community. And people came to me about the marijuana issue. They wanted to do all sorts of things that would, smoke-ins and all that sort of stuff. And I said, well, I think what you need to do is incorporate a lobby group. So I got permission from NORML, National Organization for the Reform of Marijuana Laws in the US, to use the name, and we created NORML Canada. And in those days, because people were going to jail and nobody thought it was legal, as they do now, people formed groups and lobbied and so on, and it was quite active. And also, shortly after, I think I was I was still in that role, I think, but almost transitioning out. Randy Kane came to me, charged with simple possession at the beach in White Rock, and ended up charged with possession. And he wanted to challenge the laws, and we ended up catching up to David Malmo Levine in the Court of Appeal with his a club that he had in the park in Vancouver back in those days. And Chris Clay had a shop in Toronto. And so we ended up catching up to David in the Court of Appeal, getting a dissent in the Court of Appeal, which gave us a right of appeal to the Supreme Court of Canada. And so all three cases were heard together in the Supreme Court of Canada, I think 2003. If I'm not mistaken, and the court basically said, look, this is a matter for Parliament, it's a political issue, because we were arguing that the John Stuart Mill principle of, if there's no harm or no significant harm, you shouldn't be using the criminal law and threatening people's liberty. But the court said that that principle was not a principle of fundamental justice and that we really had to do politics. And it was after that I started to become more familiar with that's actually, now that I think back of it, I incorporated the BC Compassion Club Society in '97, so I'd actually already started to be exposed to all the medical aspects, which I hadn't really been exposed to at all in the early days, even though there was stuff there, especially about China and other places that had used it in natural health care type product medicines for a long time. So it was after that that, sure, I did many, many cases and watched the industry change from
Well, that's what I'm thinking, for
all
sure.
of the imports from Colombia and Thailand and everywhere and all these big cases that we had into becoming an export economy where BC Bud became the brand, and we were supplying, I understand from U.S. Department of Justice statistics, 5% of the U.S. market, 80% of our market, shipping it into the States, and that became big business for all sorts of people for a long time. And then they legalized in Washington State and Colorado. So that again changed the whole scene to developing into what we have now.
From when you started, was it possible to even see what's coming July 1st? Could you foresee that, or did law enforcement, the government, and everyone seem so with their heels dug in that no, smoking a joint is the same as snorting a line or shooting up? That's the way it would seem to be that it was being handled.
It was certainly that way in the beginning, but don't forget, this is not the first time we've come up to a promise of legalization. I think it's the fourth or fifth time. I mean, Pierre Trudeau suggested a certain type. I mean, legalization, and it was always talked about, was decriminalization, removing it from the criminal law. Legalization goes beyond that, or it's supposed to. People now call this legalization, and really there's a huge framework of criminal law that still surrounds even the proposed Cannabis Act. But basically, there were, one was to move it to the Food and Drug Act, one was to create a new schedule. There were all kinds of different things that came up to. There were promises in the elections, and then when people got elected, they had bigger things to do, and often it fell by the wayside and never happened. This time, though, I don't expect
Seems like the
change.
genie's out of the bottle, like
This
how
time-
you
this
couldn't
time,
get it back in now if you tried.
There's mandate letters that Mr. Trudeau gave to the Minister of Justice, the Minister of Health, Minister of Public Safety, saying this is part of their mandate in their portfolio. And the act is now there. It's gone through second reading, and we've had the Health Committee hearings, and it's back in the House, and so all of that's in time. I mean, you've got, to my great surprise, all these groups, not so much, well, even the police, going on about having to train people and needing more time. The one that really surprises me is the provinces. When you know that Colorado is making $100 million per month over the last 12 months, you'd think that the provinces would be chomping at the bit. I think New Brunswick is, but...
Well, no, but as I said, wouldn't you just, like, how hard can it be to go to Colorado, spend 3 weeks there, see what works and what doesn't, bang, and implement it? It should be easy.
But it's interesting because the folks from Colorado were there at the Health Committee, Parliamentary Standing Committee on Health, when I was there, and I got to listen to them and Washington State. And then you'd still have other groups coming in saying, well, this is what's going on in Colorado, which was totally inaccurate. So there's still all this misinformation that's
seems to follow this issue constantly.
To me, it should be an easy thing to take the existing industry and regulate it. But for some reason, they seem bound and determined to create a new industry and push all the existing people out instead of bringing them all in and regulating it. I mean, with alcohol, we forgave the Bronfmans and the Seagrams and so on that were shipping all of the booze into the U.S., didn't we? I mean, so let's bring them in. We need their strains, we need their seeds, we need all of this stuff in order to be able to meet the demand that's there.
Do you think it's a good idea for every province to be able to have kind of their own rules as opposed to maybe going, you know what, let's make it easy. Here's the rules. It doesn't matter what part of the country you're in, the rules are the same.
Yeah, but we're a federal system,
right,
constitutionally. And so manufacturing, international things, those are federal responsibilities. The feds control the manufacturing of tobacco. The feds control the manufacturing of booze. But who controls distribution? The provinces. Property and civil rights, matters of a local nature in the provinces. Those are the responsibilities of the province. So that's why that. But the Cannabis Act clearly says, if you don't, province, then we will. So that there will be a national set of rules if the provinces don't jump in. And the feds have imposed upon the provincial rules all of the Tobacco Act promotion and advertising stuff, if you go to the Tobacco Act, Federal Tobacco Act, and compare it to the Cannabis Act, you'll see they're identical provisions.
Right.
And so some people have said, well, there's nothing in the Ontario legislation that deals with that. Well, it's in the Cannabis Act. So, it's going to be interesting to see how that shakes out in terms of how people promote their products or advertise and so on, which you think they would be able to do to a certain extent.
Right.
And so that's going to be an evolving thing.
I mentioned this off the top. You think it shouldn't be classified as an illegal drug, but as a natural health care product?
Well, if they didn't introduce the Cannabis Act and they took it out of Schedule 2 to the Controlled Drugs and Substances Act, it would immediately be covered by the natural health care product regulations under the Food and Drugs Act. Because if you went to those regulations, you see everything in Schedule 2 is exempted from that act. And it fits all the definitions in that act. And really, that's what it is. If you're using it for medical purposes, it's a natural health care product. But Parliament and the provinces can avoid that by, probably putting in the natural health care product regs, anything in the Cannabis Act is exempt, and create its own legislation like they have for tobacco, like they have for alcohol. So we have a federal tobacco act, we have a provincial tobacco act, and we have regulations and so on. And I think that they've clearly are following in the footsteps of tobacco and alcohol to try and do it. But as you say, there's also the U.S. model. Now, we have to remember the U.S. criminal law is not a federal responsibility, even though most people would think it is because of the way they control the drug thing with interstate commerce and other powers that they have constitutionally. Criminal law is state in each state.
Is that way the states have been allowed individually
That's what it's a part of the basis for that distinction.
We always hear that, come July, whatever it looks like July 2018, might not be what it looks like July 1st, 2020. Like, it's an ever-evolving situation, because again, we'll find out things that worked, things that didn't work. That's why it drives me crazy that we're not, we could take care of it all now in advance. But
4 plants, no more than 100 centimeters tall.
Yeah.
I mean, give me a break.
Right.
But it's a step in the right direction. And that seems to be the history, is that at least if we can get to that stage, hopefully the powers that be will see that this is really far too restrictive. You can grow 15 kilograms of tobacco on your place for you and anybody over the age of 18, as long as you don't sell it. You can make as much beer, wine, and spirits that you want and share it with your neighbor as long as you're not selling it. So, we know tobacco kills. We know alcohol is a major drug problem. If you go to your pharmacy, you'll see a poster, 80,000 kids got high last year. How? On their parents' medicine in their medical cabinet. And, I've heard kids get Xanax and they crush it up and they snort it at parties that they've got from the medicine cabinets and stuff. And you say, well, and you're going on about cookies and colorful things in dispensaries. We have not, I don't think, had any young person go in, child go into a dispensary to try and get a colorful cookie. It's the parents who leave them lying around who are the problem.
Exactly.
And so, great, we've got child-proof packaging, but they have to remember to seal them.
Yeah, exactly. The lock on the door is amazing unless you don't lock it.
Yeah.
Doesn't really matter.
Let
me ask you this
reefer madness still exists.
Before I take a question from the audience, from the viewers. What about folks that have now criminal records that deal with marijuana? Is there any talk at all about doing something for these folks?
Very little talk, and obviously something has to be done. Unfortunately, we've got to a stage in society where having a criminal record is maybe the worst thing to prejudice you. But even if you're charged and then they stay the proceedings, that's still going to prejudice you at the border. And the Crown will often not explain the basis for the stay. And it may simply be they didn't have enough evidence, so stays, withdrawals, and even beyond that, anything in a government database. And so the police might stop you in a vehicle, somebody had a joint, oh, you were in a vehicle with a joint 20 years ago, you know. People who were applying to become licensed producers had to go through security clearances, and we would get things like, so-and-so you were seen in a car with a guy on your same soccer team, but we think he's organized crime, and you're going to divert to the black market. Therefore, you're not security cleared, even though you spent maybe a couple of $1 million putting your facility together because of the process.
Right.
So having your name in a government database
is never a good thing.
is going to be, in order to clear things away, to prevent people from being prejudiced, we're going to have to go way further than just criminal records. But, you know, it should be relatively easy to eliminate a criminal record from the Canadian Police Information Computer Database. But
yeah,
will it be easy in fact and practice remains to be seen.
We're going to get another, Camille will bring in another question. You know what, I found out that thanks Camille, I found out that when you're crossing the border into the States, it's never happened to me, but the border guy can say to the U.S., you ever smoke marijuana? Really? Like, the answer is always going to be no matter what. It would be like when you get pulled over for the spot check ride. Like, why would you ever say to the guy, even if it was 25 years ago, because even if it's 20, why are you opening up that door? I'm surprised they can ask you that even.
Well, the guy in the uniform at the border has an incredible amount of discretion. And, you know, sometimes you try to have people pre-approved and things like that, and you can't. And so it's a problem. Yeah. But I knew one fellow I thought was going to put up posters on big signs at the borders with pictures of Obama and Trudeau and saying they had smoked, and so why not us type of thing, you know, in order to compare. When big important people who have to cross the border for more important reasons, they allow them to do it. But when it's somebody who smoked, as you say, 20 years ago, well, they can say no. I mean, I thought it had got better. I'd heard it was better. But
as he's asking you, you can see the sign behind him on the other side of the border that says, "Stop here for all your marijuana needs." Like, it is so ridiculous that you just scratch your head going, really? Here, Annette in Nelson asks, oh, this is a great question. Will underage kids still be charged with possession after legalization, assuming they will still be buying off the black market because they can't walk into a dispensary?
Well, that's a very interesting question that hasn't been talked about much by anybody, and I think they deliberately don't want to talk about it because, yes, the Cannabis Act defines for certain purposes the age limits for certain purposes. And for possession, distribution, and sharing amongst each other, the age limit is 12 to 17. Okay. 12 to 17-year-olds will be able to possess up to 5 grams and share amongst themselves under the Cannabis Act.
12?
Everybody else is 18 and up. Now, obviously, it's a well-intentioned provision to prevent these people
from getting charged.
12 to 17 getting records
right.
and all the rest of it.
Right.
And so it recognizes the reality that they're going to get it, they're going to share it amongst themselves. The problem is, where are they going to get it from?
Right.
You know, it's like getting your dad to go to the liquor store and get you a bottle of beer.
How many times has your kid stopped me to say, hey, could you buy me a... But, you know, that's the most thoughtful, though, the government has ever been. Just even seeing that, to me, is actually impressive.
Oh, it is impressive.
Because that's usually
I understand why politicians won't talk about that or bring it up. But, I mean, it's there, and I think it's important. And, you know, they also have all these provisions where it's going to be a ticketable type of an offense for up to certain amounts and things like that. And we don't get into the detail, but... so the officer is going to have a discretion in terms of the ticketing, or certainly if it's greater amounts to just revert to the regular process. But with youths, they will still be under the Youth Criminal Justice Act, which is a very progressive, good statute that's led to the decarceration of huge numbers of young people compared to the old days, which was very positive. And others will be under the other sections of the Cannabis Act, but you know, which I'm very critical of, where they still have a maximum penalty of 14 years imprisonment for, you know, if you break significantly the Cannabis Act. So you say, well, you know, tobacco, what, it's 2 years. Booze, it's 2 years or 3 years maybe for breaching the Tobacco Act. Right. So why are we still you know,
demonizing it.
And being excessive. It's a bit technical maybe for your viewers, but years ago, the government's introduced something called the conditional sentence order, which meant that instead of sending people to prison, there was a whole effort to reduce incarceration, because we know incarceration doesn't make people better. It usually makes them worse. It certainly exposes them to all kinds of other things that they can do when they get out. So very few people really seem to benefit from prison. We have more better sanctions that we could come up with in order to address these problems. And one of them was to keep you in the community, and you keep your job if you have one, and you keep supporting your family if you can, and so on. But you're serving a sentence, you're under various conditions, you report, all the rest of it. It's much stricter than probation. You breach, and you're back in, and you can be sent to prison for the rest of the period. So it's like the last resort. Well, the Harper government took that away for all offenses that carried penalties of 14 years and up. And it used to be for production, the max was 7 years. Well, they jacked it up to 14.
So now it doesn't apply.
So, and trafficking is life maximum. You know, I mean, there's one for, if it's under 30 grams or 3 kilograms, it's 5 less a day. But again, you say, why are we sending people to prison for certainly cannabis offenses? Surely keeping them employed if they're employed and supporting their families and so on and so forth. If you want to sanction them with other conditions and so on, do it in the community instead of forcing, people into prison. I had a case in Saskatchewan. We're seeking leave to appeal to the Supreme Court of Canada, and we managed to convince the judge that because of legalization, denunciation of the conduct, and general deterrence of others, that the decibel level of those sentencing principles had gone down. Right. And that he didn't have to look at the old cases and send this guy who was trafficking in 25 pounds, we don't know the detail. And the going rate in Saskatchewan was 12 to 18 months. And so still under 2 years.
Yes.
But so the judge agreed and couldn't give him a conditional sentence order. So he said, well, I'm going to structure the probation order sort of like a conditional sentence order and put him on probation for up to 2 years. Well, the Crown appealed it, and the Saskatchewan Court of Appeal disagreed, and
well, that
gave
could
him
open
15
the door
months.
for some good stuff. Yeah.
So we're saying, look, surely a judge can take into account legalization, especially it was not just some politician making a promise. We've got actual
it's happening.
Mandates and so on. And surely Parliament breached the Constitution by taking away the conditional sentence order because they're affecting liberty, and they went too far. They went beyond what is necessary to achieve their objective, is basically one of the constitutional arguments. So hopefully the Supreme Court of Canada will give us leave, and we'll be able to deal with that before July.
No, I know. Let me ask you this last thing. Just quickly, Leonard in Okotoks, how will police and courts handle all the stoned drivers, or is this really going to be a big an issue as some are making it out to be?
It's an incredibly difficult issue because we know that people who consume cannabis, there's going to be something in your system for 90 days and sometimes more. So it's not about immediate consumption. And so there is how are you going to, there's no machine.
Now they have drug recognition officers, which seems to be a bit of a gray area anyway at someone's interpretation.
You know, when I first started practicing, the offense was impaired driving, to drive while your ability to do so was impaired by alcohol or a drug. And officers would get you out of the car and do the roadside tests and so on and so forth. Then they brought in the .08 breathalyzer thing, which was much more technical in terms of charging and so on. But that became more common and certainly easier for the police. But we don't have the same type of device for cannabis. Sure, we've got all kinds of looking at cannabis, determining its presence. And that's the problem with Washington State, 5 nanograms. And you're presumed to be impaired, and it's not rebuttable. Whereas in Colorado, at least it's rebuttable. Right. So the problem is for the medical users. Chronic medical users are all going to be over 5 nanograms, and they're not impaired. Right. Because they've developed such a tolerance that it simply removes their, in some cases, they're better drivers because they're not experiencing the pain
while they're
that
driving.
They would have.
Right.
You know, and it's the same in the workplace. People are kicking people out of work because, oh, they've got a hot piss test for cannabis. You say, well, you know, what was their condition when they were not on cannabis? Were they able to function and do their work? I mean, surely that, and are they engaged in something where there is a safety issue? You know, so it's very, very complicated. I'm very concerned it's going to lead to very unjust situations where people are going to be treated unfairly and are going to end up maybe in prison,
right,
certainly penalized, when they really haven't, their ability to drive is not impaired. We know that currently, and we've had people driving under the influence of cannabis for at least as long as I've been practicing,
right,
45 years, and the evidence is 97% of the impaired drivers is alcohol. So we got 3% other drugs. And certainly other drugs are more than just cannabis. And unfortunately, the only way we have that would be fair, and it's certainly not the best, are these roadside tests where you are testing their motor coordination skills. Ideally, they should have a van at the roadblock with a simulated driving thing in the back where they can put the person in to test their actual ability to drive. Now, they're going to say that's too expensive. Now, I don't know, you know, if you have one of those in each town instead of hundreds of roadblocks at certain times, you might at least
They set
be able
up
to...
a stand on the side of the road that was selling Doritos. Whoever pulls over at midnight, you know what, probably gets a good bet. Otherwise, they're just trying to go home. John, thank you so much for coming in today. Right. I really appreciated meeting you. Thank you so much. John Conroy, of course, author, well-known lawyer and attorney.